Hello and welcome to the A&P. I am Alex Johansson and my co-host Patrick McCallum. Patrick.
Hello, everyone. How are you getting on?
We're having logical discussions about the state of the world. Let's get into it, brother. Hey-o, Patrick, what's going on, bud?
Not too bad at all. Not too bad.
And we have Doubting Thomas with us today. Doubting Thomas.
Happy to be here, everybody. Thank you for having me.
We are discussing Section 230 of the Federal Communication Act. It was enacted as part of the Communications Decency Act of 1996, which is Title V of the Telecommunication Act of 1996. We're going to play an initial reel to give you guys a little background, and then we will go from there.
If the intent was to totally indemnify, correct, it should say no provider or user of an interactive computer service shall be treated as the publisher, comma, a publisher, comma, or in any way responsible for the publishing of information coming from a et cetera,
even if they mess with it and whatever else like that. And the question that we've asked now twice to the Supreme Court is, and think about this question for a minute, does Section 230C1 protect any publishing conduct whatsoever? The answer is no. Goes back to what you were saying earlier. It's when they fail to remove content, they cannot be treated as the publisher or speaker who put it there or did anything with it. It doesn't protect their own publishing. And in my case, it did. It protected not only all of it, it protected it to the point that we said that doesn't make any sense, because if they can't be held accountable for their own publication decisions, at least they have to be a good Samaritan. And you know what the judge did? The judge removed Good Samaritan from the entire law. They said, oh, that doesn't apply to C1.
All right, Thomas. So discuss with me about the Good Samaritan Act and what that looks like as far as these platforms.
As far as the platforms are concerned, Good Samaritan is a protection that was given to them under the idea that they would be providing a beneficial service to the public while removing some of the liability for that. So as a platform, they could go in there and say, okay, we've got lewd content that individuals are posting on our social media platform. For example, child abuse, which breaks the law. It's in breach of the law, whether it's harassment or any illegal or illicit activity. They're allowed to remove that as a platform and, protect the agency of the people while still working within the law. Where it goes outside of that scope, outside of the Good Samaritan, is when they start attacking content that doesn't break the law, that doesn't have any of the Good Samaritan, and they then themselves remove content, let's say for misinformation purposes, even though they don't have evidence or proof, where they just remove that or at the behest of others. That's the good benefit of having the Good Samaritan law, and where they tend to go outside of that.
Okay, so we have a First Amendment issue in that they're restricting content, which means that they are acting as a publisher, even though they're a platform, right? So we have an algorithm thing where it's building algorithms, and then it's feeding you things, but they're using this Good Samaritan section of Section 230. Is that what I'm understanding? And also, they're supposed to be a good faith actor, and
C1 and C2.
Okay. All right.
Yeah, as a good faith actor, they're supposed to be protecting the public from illegal and illicit activity. But they go outside of the problem is they go outside of that scope and use that to almost act as a publisher themselves.
Right. Well, they are actually a publisher at that point. But isn't there a problem with a town square issue? Because functionally, these platforms, X, Instagram, Facebook, YouTube, they've all become the town square, right? So does it feel like they're being restricted from the town square to get their information out? Be it right, wrong, or whatever, as long as it's not in violation of the First Amendment, it should be good, provided it doesn't violate other laws, correct?
Well, we can get into that more heavily, but the issue is that they are given all the benefits and protections of both a publisher and a platform without any of the liabilities or negativity of being a publisher and a platform.
Right. So that means they can't even bring suit because they have a small Q qualified immunity. These cases just don't get there. The Ninth Circuit Court and the Fourth Circuit have both denied access to litigation against these platforms, right? Based on this 230 problem, right?
Yeah, there's an argument to be made whether it's the courts not wanting to hear it or whether it is an issue with the interpretation of the law and how it goes. But like I said, we go into it more deeply. There's other things that are involved in how the federal government's involved in it. But the general issue is that Section 230 doesn't have enough specificity in there to say that, if someone publishes content the company is not liable for it unless it's lewd or branded outside of the Good Samaritan aspect. But what happens is the company themselves, name any of the social media companies, as they all have done it, will go in there and say, well, we don't like this content, so now we're going to remove it and use Good Samaritan as a shield to protect us, even though we don't have a right to do so.
Right, but isn't the act of promoting something by generating ad revenue for a video, isn't that also a form of manipulation, right? So if everybody's okay, so what's that? The internet neutrality. Remember that, where then there was internet neutrality.
Yes, net neutrality.
Right. So
During the
first
Obama
one
days.
in, first one out. Right. If my stuff gets in there first, it's the first one. No one is going to preempt me. Right. But if a publisher says I am going to give X content creator a wider viewing range and therefore generate more money, aren't they also in partnership with that content creator to make money? Isn't that a contract issue as well? Because then they're holding down other people, which means they're suppressing speech to have other voices be heard more loudly.
That goes back to the federal involvement. Like I said, that's a deep conversation to have. The net neutrality did a few different things back then as well. So part of what net neutrality did was net neutrality attacked organizations, namely ISPs, internet service providers for those uninitiated, for going after specific companies to charge them more or less money for certain districts. So for example, if you lived, let's say in New York City, you'd pay a certain amount and have a certain bandwidth for Netflix. But if you lived in some backwater city in middle of Wisconsin, then they would give you less internet access, so your bandwidth would be lower, and they might charge you more money, that sort of thing. So net neutrality did go after things like that, but it also gave a heavier hand to the federal government to impose restrictions and impose actions upon social media companies and publishers, as well as internet service providers. And this allowed them to step in and say, hey, we want to be able to do this, we want to be able to do that. But it also gave those providers and social media platforms more conversational leeway when it came to things like what they were allowed to publish, so on and so on. And then came later on Section 230, which applied additional, let's say, benefits for these social media companies as a part of the Communications Act of 1934, which, as you know, is controlled by the federal government.
Right. So, but if I promote as a platform a creator's content, aren't I also then a publisher? Because I'm attempting to make money by putting this content creator in the fore, right?
They not only do that, they also will shut down content from other creators to raise the viewership of content from a different creator. So let's say creator A is the one they're promoting. Creator B might be somebody who is either a banned, shadow banned, lowered viewership. It can't be found in the search engines, those sort of things. Those are the type of manipulations that they do. Mm-hmm. And they claim it's protected under Section 230. And that's partly what makes them, like I said, a publisher and a platform, and why they use the protections of both to keep themselves safe, even though they tend to do that. Instead of saying, here's all the information, it's open to everybody, let the chips fall where they may, they come in there and they flip some switches, they turn some dials, and they manipulate the viewership of how things happen.
So they restrict First Amendment right access in what functionally has become a town square. And it's to make money, right? Because obviously those companies are there to make money. Corporations aren't your friend. Corporations there to further their own interests, right? So, all right. So, Thomas, we're going to switch over to Patrick here right quick. Patrick, how is the publishing functions in Ireland as far as these platforms go? Do you know the restrictions, and what kinds of laws do you guys have out in Ireland to combat these kinds of things?
Well, we do have laws on our books dealing with online publishers. Okay. We have very strict laws on misinformation, which comes under EU law as well. European Digital Services Act as well. We have reined them in over the years when it comes to misinformation, well before, but 2010 when it was proposed in the European Parliament.
Got it. Okay, so
and
who determines what is misinformation? Who decides? Who is sitting in judgment in that space?
Well, each individual country then picks what is misinformation, which is under European directives leave it up to each individual country then to regulate their own Digital Services Act, suit their own particular needs. That's where the EU works. But in Ireland, anything you can't publish anything that's slanderous online or in paper. You can't publish willfully misinformation. For instance, you can't just suddenly say the Earth is flat for whatever reason, or we all know what misinformation is when we see it. If you know what I mean, proven on fact.
Okay, right. Okay, well then let's get down into the weeds on that one. What if I tell you that I believe that the flying spaghetti monster is the god above all gods, and you tell me that I can't believe that because you have a bent that's different than that, right? Whatever it is. So is my spaghetti monster thing as a faith going to be considered, strangely enough, misinformation? Am I misinformed? Is my faith wrong? How does that work?
No, well, when we were talking about misinformation, we were talking about we all know what misinformation. What you're saying there about the flying spaghetti monster is an interesting analogy, because that was actually same debate that was brought up in multiple sectors when our laws were brought into.
Well,
what we're talking about mainly So what we mainly worry about in Ireland is slander. Where you go online and willfully lie about another person, maliciously, and it can be proven to be slander. At the moment, we are bringing in new laws which are coming in towards the end of this year, dealing with.
Who bears the burden of proof? If I say Johnny over in Munster did a thing and right, and is it on me as the individual making the claim to provide all evidentiary value that I believe that Johnny from Munster did the thing?
Yeah, that's how our slander law. That's how our slander laws work.
Okay.
So if you turn around and say Johnny down the road is X, Y, and Z, and you publish that online or in print, the person can sue you and say you prove that this is true.
Okay, so it's not incumbent on the individual who has been accused of the thing. It's incumbent on the person who's making the accusation.
Who made yes.
Got it. Okay.
Yes, that's how it works. Perfect.
All right, that makes
at the moment,
like
most modern Western countries are dealing with social media. They're all tackling with this probably same issues that most Western countries is.
Okay, now what about,
as you say, what is classified as misinformation? What isn't? Everyone's tackling with these big issues.
Right. Okay. So let's take something like flat Earth. That's pretty not controversial, right? So if I tell you that for whatever reason I believe that the Earth is flat, must I then provide evidentiary value that is scientifically backed up with evidence? Or can I just say it's my faith that the Earth is flat? Can I say that? Or am I automatically out of the running and it's misinformation?
Well, I'm just talking about for my own country. You can openly say that. But misinformation, like let's take 5G, for example. Remember that crazy theory that was going around there for a while? The whole 5G thing.
Oh, enlighten me.
We all knew
know
that
nothing of the 5G controversy.
Yeah, let's say we all knew that was. We all knew that was a load of
bollocks, huh?
Yeah. Try to find a politer word than that.
There isn't one.
And we all knew that was
absolutely.
Yeah, it was a lot of rubbish, complete rubbish, and that was obviously misinformation. We all kind of agree on that. Sort of rubbish.
I am not going to go there.
As they say, if it smells like bull, it usually is bull, and we all know it.
Right.
You know what I mean?
So, but what if there is a social contagion telling you that a biological thing that is true is not true, is published as if it were true? And I'm not going to say what it is. We all know what it is, right? At that point, what can those who are being suppressed when they're saying things that are factually true, right? When do feelings override facts? If I feel a certain way, when is that allowed to override the facts? And how does that affect things that you say? right? Because people have said things that are biologically untrue. They have been canceled the hell out of for the last few years, right? So I think that is a very, very strange thing there.
And a lot of countries are dealing with that same issue. Not just the US, nearly, not even Western countries, nearly every country is dealing with these big issues of where do we draw the line with these digital services.
Well, I think
as you say, where does missing?
Well, the problem
Yeah,
comes
the misinformation.
The problem comes into in the marketplace of ideas. Some things are being pushed as if they carry more weight than they do. Like, this is a true thing because an emotional content. I want to bring Thomas in on this one, if you don't mind, Patrick. Thomas, what's your opinion on that one?
Well, first off, I'm glad you brought up the flying spaghetti monster. Pasta be with you. Pasta be with you. I'd like to throw in actually a question for Patrick, and my question is if the Irish government is determining what is misinformation, and we know that other countries are doing it. We know a lot about France doing it. We know a lot about Germany doing it. We know about England doing it. Specifically, that if the government decides something is misinformation or disinformation, which they classify differently, or false information, which they classify differently, or information that they consider lewd, which they classify differently. There's so many classifications now. To be clear, it's just as one umbrella. That the government then decides it. The government can then apply force through arrests, indictments, or otherwise.
Yes.
So my question is, does the Irish government do that as well? And how does that affect the people if the government is now applying themselves as a publisher?
Yes, you're right. They are. We have new anti-hate speech laws, which are very similar to Scottish hate laws.
Oh, like C-16 out of Canada. The one that Jordan Peterson spoke on.
Well, I'm just going to concentrate on the Irish laws there for the moment.
I think he was asking, So, go ahead, please, Patrick.
But at the moment, hence the reason why I use a pseudonym, as they say, if people haven't figured that out by now, watching or listening to our episodes, is in the United States, you have freedom of speech, which is brilliant. But in my country, our law is called freedom of expression. And it differs from freedom of speech is if I stand in the public square in the United States and for whatever reason, I hold up a banner saying whatever you want, that is protected under the United States Constitution. In Ireland, if I did the same thing, I can, one, I can be asked to move on, or two, very rarely, Gardaí do have the power, but not to arrest you, but very rarely do just ask you to move on, 9 times out of 10. And that's about it. But we don't have the same freedom laws that you have. And now, more so when it comes to our digital content, we have very, very similar laws from Scotland, and as you can say, all across. Well, in France, Germany, and other countries, what they are the hateful content they're going after is more Muslim extremist content, which they're trying to legislate. So it's slightly different from what we're doing here. But
if I can interject, so to clarify,
but you're right. But the governments, when our government steps in, which is beginning to happen, is they make a dog's ear of it. Yeah, you're right.
I know Alpha.
We already have laws in the books dealing with slander and so on, which I've already explained. Now the fact that they're dropping ideas, freedom of ideas, is a very slippery slope.
Yeah, that's. I know I'm asking you questions as we're talking, but my questions are going to help me talk. So a statement of what the First Amendment actually is, and it's quick. I can read it if you like, but what it actually does is it protects you from the government, not necessarily publishers or each other. So the First Amendment of the United States specifically says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So what that essentially means is the government can't stop you from talking or publishing something or expressing yourself or having religion. So, so you said that your Irish government's version of it is freedom of expression.
Yes, our constitution is freedom of expression.
Right.
So
now, ours could be considered that too, because you're allowed to express your religion, you're allowed to protest, you're allowed to redress grievances. We just call it freedom of speech as an encompassing thing. It's sort of like a coin of term. So you're saying yours is different. How does that compare to what I just gave you?
Our government, we have freedom of expression. So if I turn around and I can turn around the United States saying, I don't like the flying spaghetti monster, and this is why I don't like him. And if people get upset over that, that's fair enough. Now, if I did the same thing, say in Dublin, and I go up and say, and people get upset, they can ring the Gardaí, say they feel upset and threatened by my signs or whatever I have, I can be asked to move on. Or arrested. Very rarely, they have the power to arrest you if you don't move on under public order acts.
Literally any citizen can say any other citizen has hurt their feelings, and because of offense, they can be ultimately picked up, force can be used upon them to move their body against their will to take them to a place because they said a thing that hurt somebody's feeling.
Well, I will caveat this as in fairness to our Gardaí, they do handle it very well. I can send you on videos where they do ask you to move on, and that's it. They very rarely. You have to push them quite a lot for them actually to arrest you. You really have to be a complete idiot to get arrested by the Gardaí.
Well, I understand that, but they maintain the power to remove your person for saying a thing.
Okay, yeah.
Okay,
yes.
So because the government has the power to remove your person for saying the thing, it means you have no freedom at all to express yourself. It means that the marketplace of ideas in Ireland is going to stagnate because the government has an iron grip on it if they want to. At any point, they can go from the friendly Emerald Isle to, if you say something we don't like, we'll put you in the slammer, right? Because of the laws on the books.
we found that. Yeah, we found that out very much so during COVID-19.
So the way I understand it, help me out, Patrick. The way I understand it here, then, is that the freedom of expression, freedom of assembly, and freedom of association laws under Article 40.6.1 essentially say that you have a freedom to express yourself in public among other public figures. It's the government that determines whether that expression or assembly or association breaks their rules. So our Constitution specifically, this is what people don't understand. They think it's against people and companies. It's not really what it's for. A company can say whatever they want, and an individual can say whatever they want. But the idea in America, I'll dumb it down, I'll soften it a little bit, is that America's laws are built on FU. FU and F the government, because I could go up to the president, put up both birds, and say F you, and I'm legally protected to do so. Whereas in most other governments, if not all governments around the world, they can step in and say, okay, now we're arresting you. We have more rights than you do. So my understanding is that, yes, these freedoms that are provided to you in Ireland, they're not provided to us by the government of the United States. As far as the government is concerned, they're provided to us by God, and the government has to respect them. That's actually how it's written. In Ireland, what you're saying, and help me understand, so I'm asking, it's more of a question, is are these rights then granted by government, so then government, being that the ones that they're granting the rights, can then take them away at any time?
Yes. If I stand, say, in America, and I say X, Y, and Z, 9 times out of 10, your police service, whatever state, will say, yeah, walk away as long as you're not disturbing people. You know, they're usually softy approach. Here it's different, where the Gardaí can literally ask you to move on. They have the power to arrest you. Very rarely they do. They usually give you a lot of chances just to move on and go down the street, and or very rarely are Gardaí get heavy-handed as such. Well, it's a lot to push them to that.
But they can do it. It's under the government's discretion. Yes,
they have that. Now, the strange thing with our Constitution is the freedom of expression, which is under Article 40.6.1 of our Constitution. If people can, I'll put the links down below. Is our government can regulate. They have regulated, and they are beginning to regulate what is in the public interest and order and morality. They can limit those interests and limit those rights under our Constitution. So yes, our government can step in and do it.
So the issue I have with that is an Overton window problem. When you extend those things out to the unspeakable, because the government is captured somehow ideologically, as opposed to allowing the marketplace of ideas among the citizenry to be what reigns supreme, right? You become morally bankrupt at that point, especially if someone gets a hold of your governmental apparatus. And in a small country, you can't tell me it's not a possibility, right? It's a thing that could happen. If whoever's in charge of the Dolan starts adjusting that, right, and the Shonnet can't stop them, that's a problem, right?
And no, the Shonnet can step in. Very rarely they have stepped in, but they do have the power to step in. Very rarely we have hit that issue. The only reason it's really come to the forefront is new hate speech laws. I'm a great believer is I might believe what you say, but I do believe in the right of you to say it.
Right. I might not agree with you, but I agree that you should be able to say
by the way,
thing,
that was the foundation principle. That was the foundation principle of our state, of the Republic of Ireland.
Right.
That was indeed. So the fact that these laws are slowly but surely coming in is, one, is shocking. Two, I'm not surprised. Like, a lot of people turn around and they blame the EU, they blame everyone. I don't blame the EU for these laws. These laws were brought in by our own government.
Right.
So our government brought them in to appease a certain sector of our community, certain sectors of our community. And well, as I said, use my words carefully when I say this part. When people from outside our country started coming in en masse into our country, these laws were ramped up straight away. So we're allowed to speak out to a certain degree. Again, I have to caveat this really carefully, especially where I'm living, is we're damaging the majority. The peas is a very small, delicate flowers are coming into our country.
The will of the people is being suppressed by the government. That's what's happening.
Yes.
It's what happens anytime you allow emotion to become the rule of law. Yep. Right? If someone says, I'm offended.
Emotions make bad laws.
Right.
Emotions make bad laws.
Right. Immediately after getting offended, you know what happens, Patrick? Nothing. You've chosen to be weak and not want to treat ideas and concepts, and you've decided, well, that hurt my feelings so much, I just don't want to deal with it. And I'm going to say it's a hurty word, and the hurty words are bad. And since the hurty words are bad, I can do bad things to you because now I have othered you. Unacceptable. All right.
Yeah, but even our freedom, like even our freedom of assembly, I presume your freedom of assembly as well as you have freedom of assembly.
Except during COVID, of course. Except during COVID.
Well,
except that.
Our laws have been, we have freedom of assembly as well. Same article, as I said, I'll link the specific article of our Constitution.
Wasn't there a demonstration of like 70 to 80,000 in Dublin, 2 weeks ago, right?
Yeah.
And I couldn't find anything on it. There was no TDs and nobody said anything about it.
I thought I sent you on a news article. Well, it wasn't really covered. It was between 15,000 up to 50,000 there and thereabouts, because it covered all of along the quay of Dublin. If any of you
and just based on the size of the area,
just a wall.
Right. But based on the size of the area, it couldn't allow more than 50,000 people. But if you take 50,000 people to the 5 million in your country, right, that percentage, if you were to take that percentage of Americans, of the 330 million Americans, that would be millions of people. You know, or
Yes.
a million people, roughly. If a million
Yeah.
people, or that larger percentage of people, believe a thing in your country, why isn't the Taoiseach and the Taoiseach paying very serious attention to that? That doesn't make any sense. It seems like it just gets quelled. It seems like your voices are just being suppressed there.
Oh yeah, it was interesting because I was watching it on Facebook and Twitter, because friends of mine were sending me this link because in a previous career, I used to drive up and down Dublin quite a lot. And they were saying, there's this massive thing going on in Dublin and such. And I was looking at it live. And then the news came on that night.
Did the RTE even cover it?
No, they did, in fairness. They covered for about 30 seconds. There was a demonstration, such and such, and then on to the next thing.
So 50,000 people have an opinion, and RTE doesn't want to take a look at that?
Well, they did interview the Taoiseach a couple of days later.
Okay.
And
the Prime Minister,
basically labeled them all as Taoiseach, yeah. Taoiseach and the Taoiseach both were interviewed separately, but they both had the same talking points of, these are all right-wing extremists and so on and so forth. Now,
50,000 of them?
Okay. Yeah. Like, you're saying that talking point is wearing a bit thin when there's different people from all around the country.
Well, it reminds me
different
of the UK.
backgrounds.
That reminds me of the UK. What is that? Two-tier Keir? I mean, Keir Starmer. You know, Keir Starmer, right?
Yeah, as I said, the UK has always been a basket case when it comes to lots of things. By the way, asking an Irishman about the UK is, we're not going to have a positive opinion.
But they're your neighbors. Shouldn't you love your neighbors, sir?
Look at the last 500 years how our neighbors looked after us. Right, let's get back on topic.
Well, I think they're still in possession of 6 of your counties, if I recall correctly.
Yeah. Well, I said correctly. That. I hope I will say one thing. It will be interesting to see that in a couple of years. But let's get back on. Actually, we will come to that in a future episode.
I have a question. I have a question for Patrick.
Yes.
This is a quick one. So you guys have these demonstrations out there, and you guys have these laws we just discussed. So sort of help tie it together. Do you think that those public assemblies are helpful? And do you believe that there is a way, in your opinion, to strengthen your freedoms? Or are they just being too oppressed by the government and there needs to be a referendum?
The right to assembly, it hasn't been touched yet. And I'm saying that our constitution mostly has to be changed, or our constitution's changed through a referendum. So our freedom of assembly, you can't limit people's access. So you can have a demonstration. So the way they get around this is, say if we were marching up the road, saying we're having an assembly, they can argue that this is going to block the public's right to transit from A to B. So that's how they can get around.
So it's a violation of mercantile function by disallowing those to proceed through.
There's other restrictions where
we have that here
not
too.
Allowed. Technically, in the House of the Oireachtas. Remember the House of the Oireachtas when we covered in a previous episode?
Right. The Dul Éireann and the Sean.
You may not hold a procession, or under our constitution, you may not hold a procession or a meeting within a half mile of the House of the Oireachtas without a chief superintendent or higher rank. And for performance, you have to basically get Gardaí's permission. And 9 times out of 10, very rarely do the Gardaí not give that permission. There was during COVID, all right, they did stop.
Right, but they can stop that demonstration cold by just saying no, and then if anyone shows up, then they get arrested. Hey,
within a half mile. Yeah, within a half a mile of the House of the Oireachtas, which is in the centre of Dublin. Remember, so would it say take half mile radius, so you can protest anywhere outside that half mile. If you want to go within that half mile of the House of the Oireachtas, you have to get, obviously Garda permission and so on.
Mm-hmm.
Yeah. They can also stop you if you're blocking, public highways and so on. But most times, usually, that's why if you ever notice a lot of our demonstrations are usually held in parks.
Well, right, they have to, because then you don't stop mercantile
Yes,
function.
that's
by
how we
doing
get
that.
around. That's how that. I think a lot of people in Ireland don't realize why we do that, why we protest in parks.
Well,
That's
so
why.
there are huge tracts of space in DC that functionally you can do that, right? It's
Yeah.
public land, and
Yes, public land.
right, public
Yeah,
land. So that
yeah,
they
pretty much.
absolutely cannot stop you in the United States from
Yes.
using those spaces for that purpose, right?
Yeah,
The problem
but
comes
obviously, if
in-
your protest,
Go ahead. If you're
but
protesting.
if your protest is spilt out to a public highway, obviously that then they can stop
Yeah,
it.
and we've had a lot of
yeah.
people in the United States who've decided to literally stop freeway traffic by getting their bodies up on the freeway, which is
yes, we have them here
insane.
too.
That
Yes,
doesn't
we
make
have
any
them here
sense.
too. What's it called? Something. Right to oil? No to oil. That's the crowd I'm trying to think of. No to oil. Yes, no to oil.
The oil knuckleheads, right?
The oil people. Yes, they're coming to my mind because some of them have been prosecuted lately in Ireland and UK and other places from doing crazy mad things.
I remember the oil people stopped a canola oil tanker. I was like, oh my god, that's not the kind of oil you guys are worried about. That's cooking oil. Oh, not bright. That went sideways.
And then they get upset when they get prosecuted.
That seems strange. All right, so let's get on to this Tim Pool thing. Let's get this thing fired up, see what he's got to say.
Facebook blocks Charlestown, West Virginia City Council candidate's page with no further appeal. This is the censorship machine that is currently going on. So let's see. We got a new system that we are just setting up right now. So this will be our first use of this system. And I want to make sure we have it all working properly. So I believe we have Jason currently standing by. I'm going to be pulling him in now. Let's see if we can get this working properly.
We had the one show I came in and I explained a lot of it, but we figured out that and see this, people need to understand how this translates, right? My case was about business, right? It's an antitrust. And the case, basically, Facebook came in and they wiped me out because they take money from my direct competitors to essentially manipulate the algorithm anti-competitively. Now, the thing is that that's essentially a viewpoint discrimination, right?
So, Thomas, this is the thing you were talking about earlier with antitrust. So speak to this a little bit for me.
When it comes to the antitrust situation and how that applies, are you talking about like in the U.S. or in other countries?
Well, in the U.S., because what he said is they restricted access for him so that they could promote others, right? That's exactly what you were talking about before, right?
Yeah, they don't do it just here, though. They do it other places, too. That's why I was asking if we're talking specifically about the U.S. jurisdiction.
Well, just U.S. and Facebook on this one, the one he has the case with.
Right. So when it comes to what they're doing, like with politicians or in his particular case, they're allowing these companies to almost act like voice monopolies, speech monopolies, and they get to determine what is said and what isn't said. And this does dive into the federal government situation. And this is a proven thing. This is a fact. This is something you could reference. The federal government, and this was under the Biden administration specifically, was given office space. We're talking about desks, computers, the whole 9 yards, for federal officials, namely within the FBI, to come in and have a thought pattern as to what that could be said or could be published or what could be determined as misinformation. So they would get a call or they would be voiced in on a meeting and they would say, hey, we want this piece of information we believe is misinformation, or we believe that this is breaking national security because there might be some Russian misinformation getting tossed in there. That was tossed around a lot in public media at the time. And that is a unholy marriage, as far as my opinion is concerned, between the federal government and these private entities, these companies, and how they're allowed to publish their information. And instead of going after them for antitrust laws, which most people, again, refer to them under like monopolies or protections of individuals for, say, like, vehicles being safe enough so that they don't cause car accidents if you buy a brand new vehicle from a manufacturer, those sort of things. In breach of those antitrust laws, we don't have a redress of grievances. And we've mentioned redress of grievances before. We don't have the opportunity to go to the government and say, hey, you stepped in and did this. We want to be able to take them to court. So he's having issues because the courts are kicking it to the curb, sending him to the side, saying, you can't talk about this. Now he's finally getting an opportunity to go up to the Supreme Court and say, we have to have this addressed. We have to have this unholy union looked at. We have to have these antitrust laws enforced, which they're not being enforced. That's really where it all comes in. It's this unholy marriage, as I call it, between the private organizations and the federal government.
In Article 3 of the Constitution, we have the judicial branch, and those are all set up by the Article 1 branch, the congressional branch, except for the Supreme Court, right? So all of the Article 3 inferior courts underneath the Supreme Court are set up from the Article 1. So the Superior Court of California was presented with this man's case. It went to district court, it went to the appeals court, and now it's officially docketed at the Supreme Court. So he's had no ability to redress at every other level below the actual named Article 3 judicial branch, the Supreme Court of the United States. So here we go.
It's just based on money. The translation here is that viewpoint discrimination, even built in the algorithm or the product design or however it is, yes, it is their First Amendment right to do so, but when they do so, they actually have to justify it under Section 230. The problem is that hasn't occurred. A lot of people are completely unaware that the courts are applying Section 230 as an immunity from suit, right? What I mean by that is that you don't get into court at all. They say you cannot be treated as a publisher, meaning the platforms, and you're done. That's it. And that's essentially what they said. They said that everything Facebook did is irrelevant because they can't be treated as a publisher because it was my content. Well, that's wrong. And it's wrong on so many levels that we can prove it in so many ways. For one thing, back in 2007, Judge Trauger out of Tennessee actually determined that Section 230 doesn't provide immunity from suit. It's supposed to be a justifiable protection. The thing is, if there's no justification, they can do anything they want. Well, there you have it. If these platforms can do anything they want with absolutely no accountability, because the courts won't hold them accountable, they can censor any way they want. So
they're immune from prosecution, Patrick. In the United States, that's a thing that's not supposed to be happening that way, right? So, yeah, we're going to have to definitely...
So it's 100% immunity.
Yes, they are completely immune from suit in these cases.
Okay. So in the United States, I can publish whatever I want online about anything I want.
Well, the issue is that the platform is dictating the content by restricting it or pushing it for algorithmic purposes to make more money. So if I make more money than, say, Thomas does, then they're going to want to generate more ad revenue. So they're going to shadow ban.
Business, after all.
It's a business, right? But it's still in violation of free speech based on them functionally being a town square.
Let's start from the beginning real quick. This is Section 2, Section 230. It's the Telecommunications Decency Act. Is I have that right?
Yes, the Communications Decency Act.
Communications. It's been a long time since we covered this, but this was a huge story, 8 or so years ago, when this immunity was basically being used by big tech platforms to censor conservatives. The media lied about it the whole time, and they were trying to stop Donald Trump from having support. They were banning tons of individuals. They were proposing ideological rules. This was, of course, I had the moment on Joe Rogan where we talked about the misgendering policy, but this still exists. So is it my understanding that your lawsuit could do away with that perception of immunity?
It could change the world. It could change and that's actually not an understatement.
That's not hyperbole. He's actually correct. If this goes through and those platforms get treated as a space where litigious behavior can occur, then a lot of these free speech things and algorithms, like a lot of things are going to change. It's going to be functionally a net neutrality for the information in what has commonly become the public square across X, Instagram, Facebook, YouTube, all these publishers are also going to be responsible if they adjust content in any way as being complicit in publishing that content.
It's probably one of the most consequential lawsuits that nobody's paying attention to. And that's the reason why I'm dealing with so much opposition, is because it will change the entire economy. And here's why. If all of a sudden they are actually accountable for their own conduct, which is procedurally correct, it's based on the text, that's correct. The Ninth Circuit won't do it, right? Because so California, there's a problem in California courts, which of course, is always implied. We always kind of know it, but no, we've actually proven it. And here's why. We're not coming back to the Supreme Court this time with just our hat in hand and saying this is how it works. No. In fact, the Third Circuit, Fourth Circuit, and Fifth Circuit have all said exactly what we have been arguing since day one in 2018.
So there's an issue, and I want Thomas to speak to this. Since we have 94 divisions or districts of district courts, we're ending up with a ton of differences of opinion, right? So if the third district court says, we'll just take the Second Amendment because it's such a popular little thing. There are, say, 25 states that have constitutional carry, but there's other districts, especially in the 9th district with Hawaii, California, Oregon, and Washington, where it is an obvious restriction on certain rights because other places do it differently, right? So your ability to, say, carry a firearm in Tennessee or Arizona is very different than your ability in California or Hawaii based on case law and precedent in those districts, right? But the same thing happens here. He said the 3rd, 4th, 5th districts say X thing, but then the 9th district in California and Hawaii say something completely different, right? It means that the 9th Circuit will not even entertain these things. And even though the 3rd, 4th, and 5th districts entertain them and say this is the way it is, since it hasn't gone above them, and those companies are placed in Delaware, California, and some certain other places, the laws affect them differently based on precedent. Thomas?
I will say, in my opinion, that is a failure of government, namely the federal government. Under our Constitution and the Bill of Rights, it is the federal government's obligation to protect those rights. Now, we have the 10th Amendment, we have the Supremacy Clause. Those are often overlooked. But the problem is that because of the Supremacy Clause, the federal government is supposed to step in and work between the states and say, here is our rights, not privileges, to be clear. Here's our rights. And each state of the union, each individual segment of the country has to respect those rights because they're not laws and they're not privileges. So if I live in state, let's say I live in Tennessee, like you said, I live in Tennessee and I want to travel to Kentucky, I should have the same rights between one state and another, and the states shouldn't be able to create laws to dictate that. It is the federal government's job to go in and sue them. This is a great tie-in, so I'm glad you brought it up, for speech. It would be the same problem if you were allowed to say something in Tennessee, but then you went to Kentucky to go say it. Let's say you're a politician, you're trying to become a member of the federal government, so you need to rally support in many states. Say the president, that's a common position people understand that you go to different states for. And that state that says, well, you're not allowed to say that because we've banned that law. And well, no, I have a right under the Constitution. And then the state goes, nope, doesn't matter. We made a law. You can't do it now. And the federal government neglects to step in and do something about it. That's where it becomes an issue. And I'm also glad that he pointed out and you added to it, that will change the world. What we'll do is it will state to other countries that if your members, your citizens, want to use our platforms and say something, they fall under American jurisdictional rights. So if they want to say something and the publishers or the platforms allow it, then those things are open to be said. It's up to your government to then, and it's between you and the government, your citizenry and your government, to argue about whether that platform or publisher should be banned from your country. France is famous for doing that. France has gone over to platforms like Rumble and said, hey, we don't like your platform. You're not allowed to publish here. And Rumble gave them the finger and said, okay, then we won't ban us. Like, we're not going to stop your people from posting whatever they want because we fall under American jurisdiction That's where our rules lie. And if you ban us, that's your problem. That's not us. We'll leave it up to your citizenry to fight you about that. But we're not going to change the rules in opposition to your citizens' rights and what we believe are rights because you said so. We're not gonna toe the line for that. You'll have to ban it, and you'll have to deal with the repercussions of your citizens.
Right. Macron doesn't like that at all. He did not like that.
No, he doesn't.
Kowtowing to the Americans was not a thing he thought was cool. All right, here we go.
We were right. The court just won't do it. So the only court that can deal with a circuit conflict like this is, of course, the Supreme Court. That's why we're here.
What's the elevator pitch of your argument to the Supreme Court for the layman?
Elevator pitch. Okay, so there's 4 reasons that the courts are doing this wrong, right?
Well, so let's start with like what is wrong? How should this work on the internet? What should be happening for the average person?
Okay, so this is how it should work, right? The platforms are supposed to be a neutral public forum, right? And what I mean by that is that they are supposed to act evenly across all boards, but if they censor, right? If they take down any content, they're supposed to be doing so in good faith. Everybody knows that, and people argue it's the terms otherwise objectionable. No, it doesn't matter, because if they don't actually get to court, meaning it's immunity from suit, you never have to prove that they acted in good faith, meaning they can do anything they want. Go ahead.
Real quick, it sounds like here's how it's basically been operating. Facebook will create rules where they're like, if you support, American natalism, right? If you think white people should have babies, you're a white supremacist, and we will ban you. And so they've enacted policies much like this, and we see this, frequently, especially in the past 8 years on Facebook. And the story today, of course, that I'm showing is they've banned a conservative running for city council in Charlestown, West Virginia, under false pretenses. And they can argue we have the right to ban anyone we want and push forward any rule base we want and determine that anything we want is objectionable. So,
wait. So let me interject something here. This is a good point. Who are they going to argue that to, Tim?
To the courts. Oh, you're right.
They don't have to argue it to the courts because you never get in the door.
Exactly.
They never consider the facts of the merits. That right there is the fundamental problem. They don't have to argue that they did anything in good faith or that they did anything legal or otherwise, because the courts truly believe they cannot be treated as public.
So wait. This is really interesting then. The problem the problem we have right now with these big tech platforms is that while they do have correct me if I'm wrong, they do have some kind of protection, but you can never challenge whether they broke the rules because the protection is universal.
Absolute.
It's
absolute immunity.
So
and the strange part is not only did the Tennessee court say that it wasn't immunity, the Ninth Circuit itself in Barnes held that 230C1 is not an immunity from suit. They're doing it procedurally wrong continuously, meaning they're doing it on purpose. So they're not applying it correctly and immunizing them when they want.
So you see the problem there, Patrick?
Yeah, I see it there now.
So if you disallow access to redress, then that means that the corporation or whatever entity has a hammerlock on it. They can do whatever they want. And when you control that much of the town square, you control the ideology of a people.
Yes.
So it becomes a giant psyop where whatever they believe is a right thing, and a counter voice can't come to the fore. Thomas?
I missed the question. I'm sorry.
It's all good. So if you get disallowed redress in the court, it causes an ideological backwater where you cannot have a marketplace of ideas that's effective, correct?
No, I agree with you. I'm sorry. I agree with you.
Here we go.
Ramifications of your Supreme Court suit be not that a company would lose Section 230 protections as they're written, but they would be subject to lawsuit to determine whether or not it does fall under Section 230?
You nailed it. The point is, it changes the idea that they can get out of suit entirely. It means procedurally, and this is proven. I mean, this case law proves this. You are supposed to, and this is the formal way. So any attorneys that are listening to it, it is to go from a 12b6 dismissal immunity from suit, meaning you never consider the merits or the facts. It's supposed to convert to summary judgment Rule 56. That was never done in my case at all. They never considered the merits. They didn't care what happened. If it converts to a summary judgment, then you get into what happened. Well,
Wow.
You're saying, well, they're arguing with somebody that they can do this or that or the other. With who? You never get to court. I never once saw a court.
When is your hearing taking place with SCOTUS?
All right, so this is the process. It is now formally docketed. Like I said, this is a monster. This is we have, and it's not to be discussed today, but I think you're going to see we're going to have a lot more support this time around because a lot of people have recognized throughout the 7 years I've been in a legal battle, we're right. The question is, if we go to the Supreme Court, right, and the Supreme Court, has to decide whether to hear our case. That's what's vital here. Everybody should be supporting what I'm doing. Everybody should be talking to everybody about it because if the Supreme Court takes this case, our argument's indisputable. It's not whether we're right or wrong. We're right. All the court has to do, and this is as simple as it gets, Tim. I'm not even kidding. One sentence. If the court affirms that 230C1 is not an immunity from suit and does not protect any first party conduct at all, it resolves everything.
Here's the deal. So as an American citizen, you should be provided the opportunity to redress in court a conflict with another entity. Every other court up to SCOTUS, and understand he's docketed, if they even hear the case, then down the line, even if he doesn't win, they're going to have to start hearing the cases based on a procedural error that they've been violating in the past. Now, when he gets there, the merits of his case are really, really good. The odds that he loses if he gets there is pretty low, but if he does, it's still going to encourage more of these kinds of suits in this public square in the interwebnet space is concerned.
Well, it took him, what, 7 years to get here?
Oh, yeah. Oh, yeah.
Something like that,
7 years.
Yes.
Yep. So he's docketed. So he's docketed right now. How long from being docketed, as he said?
So
actually,
when you get docketed in the Supreme Court, it just means that you're on the calendar. And as the time gets closer, then the clerks at the Supreme Court will let all parties know that they have X amount, they have X date to have certain arguments prepared. Right. So a lot of the arguments.
How long is that process?
Oh my God. It could be anywhere from with all these violations and these injunctions that Trump is going through. It could be 13 hours to 13 years, but it's officially docketed.
Wow.
It means normally it should be heard before the end of next year's calendar, right? So anytime from now until November of next year is your time frame.
About 18 months,
at.
roughly. Yeah, roughly.
Yeah.
Okay.
It could
Why
be.
I bring up a lot of the federal stuff is because we have a right to redress of grievances, and because the federal government has to listen to us, has to. We have the right to go to a court and say, that's why there's been a joke that you could sue a ham sandwich if you want to. Now, there's a sort of sniff test involved where the government can be like, okay, it's an inanimate object. You can't sue an inanimate object. There's a bit of, there's a tiny, tiny, tiny sliver of leeway that they have, but they are not even remotely allowed to abuse that. It has to be so absurd that you want to sue in a sandwich, right? Like, so that sort of thing.
There's a thing called a specious lawsuit. If something is specious, it's silly, right? If you're suing that ham sandwich for not having cheese, say, this ham sandwich didn't have a slice of Swiss cheese on it, right? Okay, that's specious. Like, stop.
They're called slap suits as well, aren't they? In certain quarters.
They could be. I'm not exactly sure the terminology. I'm not a lawyer. I dealt with some legal stuff in the past.
Silly lawsuits, slap lawsuits. I think you have, some of your states have anti-slap lawsuit laws, don't you?
Well, slaps are a different thing. Yeah, that's a bit different.
If I continue to file suit against the same entity, they'll eventually say you have to stop doing that. Like, stop suing the ham sandwich people because there's no Swiss cheese. Just go to a different deli and order with a friggin' slice of cheese on it, bro. Like, fix yourself.
Just go away and cop on.
Get a turkey sandwich or get a Dagwood or get a BLT, something.
entire internet. It converts 230 back to the original way that it's supposed to apply, meaning they don't lose 230 protections. They will still have liability protections. What it does mean is they will actually have to do it in good faith. They will have to go after otherwise objectionable content. And if they don't and break a law, they go to court. And guess what? Then they have to prove it, as you said, but to an actual jury of their peers.
There's another side to this too, because tons and tons of lewd content was allowed. Very bad stuff.
Yeah.
Bad guys doing bad things to people. Certain kinds of very unsavory acts were allowed to be shown.
Especially these deep fake.
Oh God,
that's going around at the moment.
Right. And then and now you also have AI content that tends to slip under the wire because they can't quite tell exactly what it is, right? So some of that stuff's sliding through too. So, but they're going to be responsible for the lewd stuff that they allow through, right? And then they're also going to be held accountable if they use algorithms or other things to block certain kinds of content or distribution of just normal content. I have an opinion. I like the spaghetti monster and ham sandwiches with a slice of Swiss on them. We don't like that. That's this kind of view. You can't like that kind of sandwich. You have to eat turkey sandwiches, or even worse.
What's wrong, Pete? What's wrong, Pete? What's wrong, Pete?
These weren't just lewd statements. This content was illegal. It was harmful to, let's say, children, for example, to give a more prime example. It wasn't somebody said a naughty thing I didn't like. It was, here is abuse, or here is lying. Those sort of things that are against the law.
Yeah.
Here we go.
This is
now all of a sudden they're responsible.
It's fascinating. You know, I deal with defamation all the time, as I'm sure you do too. And even with Times v. Sullivan and anti-SLAPP laws, you still get to go to court. You still get to sue. These are just protections they have. So for those that aren't familiar, let's talk about, like, Times v. Sullivan is a precedent that says that if you're, I'm paraphrasing, so, you know, bear with me, I'm not a lawyer. If you're a public figure and someone defames you, you have to prove that they either knew they were lying or they were reckless. They had a reckless disregard for the truth. However, either way, if I were to sue someone for defamation, I get to file in court. I get to go to court. They just have the opportunity to issue a dismissal under that precedent, but they still have to send a lawyer in. So with anti-SLAPP, it's very similar. States have created what's called anti-strategic lawsuits against public participation. And the argument is, if you're suing a newspaper or suing someone for defamation, they can file anti-SLAPP to get the case dismissed. It sounds like what you're saying with Section 230 is they don't even give you an opportunity to argue. They just say outright, Section 230, your suit's gone, and we won't even hear what you have to say.
Correct. It is the equivalent of coming in there, them you saying that they defamed you. And as you said, a lawyer has to go in. You have to have a hearing. It converts to a summary judgment. Now, it can be dismissed early under summary.
So temporary restraining orders, preliminary injunctions, and summary judgments are three very different things. So temporary restraining order is an emergent issue that you have to have something to stop a process because it will have an irreversible or emergent effect. Preliminary injunction is a TRO that gets held across the entire time of litigation. And the summary judgment is what happens after all arguments have been heard. So if a 230 case goes up against these platforms, it immediately goes to a summary judgment of no. It just no, right? That's where that goes. Which is an issue because the summary judgment here doesn't indicate that the litigation has occurred. It indicates it's a violation of 230, and we're just going to move on from there.
Judgment, meaning if it's facially non-defamatory, all right, we don't need to go to court, right? It's essentially failure to show cause. However, in this circumstance, what I'm saying that occurred, I mean, it occurred in my case. It happened to me. The court said, we don't care about any of the merits. We don't care what happened. You cannot treat them as a publisher for their own publishing conduct. Goodbye.
So they didn't even let you make the argument then is,
nope.
Section 230 applies under certain conditions, And I argue they have not met those conditions. And the court basically said, we don't care what you think.
We don't care.
Bye. Dismissed.
Correct.
Can't sue.
Correct. You can't be a publisher. And
So
that inherently is the argument that everybody's struggling with is, are they a platform or are they a publisher? They are both. They are a platform, right? The dominant party, but they are also acting as a publisher. In other words, they're exerting their own First Amendment rights, but the court doesn't believe that they can be treated as a publisher simply because content originates from a third party. What if they change it? What if they, let's just say, what if they recommend it, right? That's one that's confusing to everybody. Well, if they're recommending it, they're developing that information, right? Meaning they're picking that this information is good to advance or restrict. Well, as soon as they start to develop the information, they are exerting their First Amendment rights. They become an information content provider. That's the actual definition of it, which is a publisher. And meanwhile, the court says, we can't treat them as a publisher.
So you see where that's an issue, right? They become a publisher.
Yeah.
So here we go.
Defeated, meaning it actually violates the congressional intent. And lastly, if you cannot get legal remedy for someone restraining your individual civil liberties, which is exactly what they're doing, if you have no legal remedy as immunity from suit, that's a violation of the Fifth Amendment due process rights. I have a right to go after Facebook, and the courts are preventing me from engaging in that right.
See the problem, Thomas? That's what you were talking about before. Can you expand on that a little bit for me?
Beyond what's already been said, especially with your references there, because you added some great references. The states, the federal government and the states both have a obligation to support his rights as well as our rights to speech and redress of grievances. And I'm trying to choose my words carefully, they've neglected to do so. It is their obligation. They have to hear those cases, even if they don't like it.
Right.
Does that make sense?
Yeah, it's a violation of both the First and Fifth Amendment. Seeking redress and then the ability to speak, but then when you restrict someone else's speech, that's the problem. So you restrict
and be afforded due process.
Right.
That is also in there. Yeah.
Right. And as a citizen of the United States, you have that Fifth Amendment right to attempt to find that redress in the judicial system.
It's an unconstitutional mess.
That was a really interesting point you made last time you were on Timcast IRL, was that the A versus the A publisher and the publisher mean two completely different things.
Yep,
you can be a publisher of the content, meaning there's more than one, or the as the sole responsibility of that content, right, which makes for an interesting legal case. Now, a lot of people have said, "Oh, that's silly," but I think that will be interesting to get clarification. One last quick.
It's the text. You're supposed to follow the text.
Real quick, we've got about 2 minutes. If you win, what happens? How will the landscape change?
This is up there with Brown versus Board of Education. This will fundamentally change America. Censorship will die down dramatically. It will still occur, but it will occur in good faith if they seek legal protections. The companies that are not engaging in this kind of overt censorship don't need to worry, because they won't be held accountable. More lawsuits will occur. I mean, that's going to happen. And many of them are going to have to supersede a summary judgment hearing. The thing is, we've at least got to get to a summary judgment hearing. So if this gets sorted out, it means that those lawyers that are saying you'll just get.
So remember I said you have to get to a summary judgment hearing. That means that all the litigation has occurred. It means we've gone through orders to show cause. We've shown cause. We've gone through the discovery phase, right? And then we've gone through the actual litigation and hearings and all those things that are required. And then once all those things are put together with a jury, you then get a summary judgment based on the actual merits of the case with all of those steps being followed. Now, if you just go from no order to show cause to summary judgment based on a 230 situation where the publisher can't be or the platform can't be held accountable, then you don't actually have a summary judgment based on the merits of the case as it has been litigated, right? So that's a huge problem, and it's restricted our speech, and the marketplace of ideas has become drowned in just some absolute abject sewage.
get thrown out are wrong. And I'll actually add this. If you want to go after Wikipedia, and James knows me, even yourself, if you want to go after Wikipedia, oh yeah. The thing is, I act as an expert consultant for other lawyers that want to break through this, because although it has not been unified by the Supreme Court yet, we know it's right. We know how to fight it. And if you get a decent judge, you can actually get through this. The third, fourth, and fifth circuit has set precedent, meaning if you get to sue in those state, in those jurisdictions, you will make it through Section 230 now. It's just unfortunate the lawyers are just not aware of how it actually works.
Yeah. I'm surprised it's gone this far with Section 230 as long as it has, because it defies logic.
What's really strange is Justice Thomas himself has put out 3 different decisions in which he's calling for a case that is identical to mine. Mine nails it. This is the 3rd time we're going to the Supreme Court. It's indisputable. We need the Supreme Court to take this, period. It affects literally millions, if not billions of people worldwide, because it will change free speech in America overnight.
Interesting.
It's huge.
So it's been docketed, but I suppose the issue is they may reject it. They could say, we're not going to take this up.
Yep. And then meanwhile, the Supreme Court, and it's funny because there's lots of decisions that they go after and they take up cases. This one affects more people than any other case out there, because literally everybody uses the internet, and this affects everyone, because behind me, everyone else is sitting there going, we can't sue because the courts won't let us in, because lawyers won't even take it. It's basically a violation of due process because it chills due process.
Right. It's an egregious violation of due process. Right. And again, the Fifth Amendment says you can attempt to get your redress. You can attempt to do this. You are, as a citizen of the United States, like, we expect you in an attempt to get redress to utilize this system that has been put in place. Right.
And just to tie that up, if you're a betting man, do you think he'll win it?
You should. If he gets hurt,
Yeah.
he will win.
Yeah.
Because
that's partly why they have been pushing this and kicking the can down the road.
Because the merits of the case functionally, we can go over the other episode they did on Timcast IRL. So it has to do with a publisher versus the publisher, right? If you are the publisher and you are the sole individual going through a platform to put some information out there, then you, if you weren't adjusted by the platform, are right? You can be a publisher or a group of publishers that are the publisher of a creative concept, idea, video, whatever media you're using, right?
Wikipedia.
So, right. So if you are the publisher and the platform becomes the publisher with the individual content creator, right? So let's say even our podcast, right? Let's say that some entity decides that there are some words that we use that they didn't like. Right. And they're like, no. You're getting demonetized. There's zero algorithm. Like, all these things are going to happen. Right. They become with us the publisher of the content. Right. Not just a random publisher, but they are the publisher in conjunction with us to algorithmically and then adjust content to put it out to make it more, in quotes, palatable, or for whatever reason they did it. It doesn't matter the reason that they did it, but they become the publisher with us as an individual content creator, right?
Yeah.
And that's just the verbiage of the text. The word "the" there is absolutely, like, central.
And this gentleman here, where does he get? I presume it's a very expensive process that he's going through at the moment.
Yes, millions of dollars has been spent.
Yes.
To attempt to get this where it's going. So he was on Facebook years and years and years ago, and all of his content one day was literally just ripped. All of it gone. His channel gone. Everything just boom, gone.
Okay.
And he's like, hey, you can't do that. You're a platform. They're like, yeah, go ahead and sue us. Thanks. And then he hit the wall in 230 and hit the wall in 230. Just kept hitting the wall. Because somehow the Ninth District
where's and I presume it's down to people's good faith that he's continuing this fight.
He is being funded from the outside. I can't conceive of him as an individual making that money, but some people have money. I don't know.
Wow. Okay.
Yep. So here we go.
That stops people from even holding them accountable. That's a problem. That's a big problem.
The scary thing, I suppose, is Supreme Court they don't like taking up these big cases that have massive ramifications very often. So I suppose
Nobody
we'll
else
see.
can fix this.
Yeah.
The California courts won't fix it, and no other court can settle when we have here's where we're at. 3 circuits against the Ninth Circuit. The Ninth Circuit conflicts with the Ninth Circuit. The lower court, district court under the Ninth Circuit conflicts with itself. It violates the constitutional rights. It's violated my constitutional rights, and it affects every single American that is using the internet.
We do
There is no other court other than the Supreme Court that should be dealing with this.
I look forward. I hope they do pick it up. Jason, it's been awesome to have you. We got to bounce, but where can people find you?
Socialmediafreedom.org. You can contact me through there. I'm also on Twitter at JasonFYK. My last name, Jason FYK.
All right, man. Well, thanks for hanging out. I really do appreciate it. And we'll hear from you next time.
All right. Thanks, Tim.
Take care.
So he's absolutely correct.
Yeah.
Absolutely correct. The Supreme Court in the United States is the only one that can handle this based on the scope and the issue. 3rd, 4th, and 5th districts say, yes, hear it, right? But the 9th district says no. So the Superior Court said no. The appellate court said we want to hear it. And then the district court said no, right? Well, let me get, I don't know. Hold on.
So they just kicked it up they kicked it up the line to
No.
Court.
They issued a summary judgment that said no.
Yeah.
They didn't kick it anywhere.
Okay.
They just told him they didn't kick it anywhere, right?
Okay.
So the Superior Court
Right.
said we're gonna. The district court said no. Hold on. Superior Court said no. The district court said we want to hear it. They had an en banc, which is like a 3-judge panel, or en banc with all the 9th district, and they said absolutely not, right, at the appellate. And then the Supreme Court, it now has it docketed, right? So somewhere in that process,
Okay.
right, one says yay, one says nay, one says yay. I'm not exactly sure 100% on who said yes or no, but they're all in conflict.
Yeah.
They've all issued rulings, most of them summary judgments based on
But at the end of
the
the
230.
so at the end of the day, just to wrap it up, as they say, the Supreme Court hopefully will hear his case within the next year and a half, roughly time period. You're saying.
Hopefully. We'll let Thomas get a little bit in here, and then we're going to go ahead and send this one to post.
I agree with everything you said. Really, I think we've nailed it. I think we've tore this conversation apart and seen all the nitty gritty of it. The only thing I would like to add and mention is how we talked about federal policy. Like, I keep circling back to that and how it works, because he mentioned that it'll change the world. It'll be like many other Brown versus Board of Ed and Bruin and all those other cases that it'll resemble, and it will, because it'll not just affect the U.S., but it'll affect policy around the world. It gives us the ability to enforce other policies. Everyone's freaking out about tariffs right now. It's a different conversation, but we had this problem with TikTok, where TikTok is owned and controlled by an outside entity. And what the federal government has said is, hey, we want to bring TikTok into the U.S. for a lot of reasons. Security is the main one. But we want to bring TikTok into the United States. You can operate your own TikTok in your own country, but we want to have our own here. And if not, we might have to consider a security reason, to ban it potentially. That would have also provided them with the opportunity to have the same protections here for U.S. citizens. So if, let's say, this whole thing goes through with Bill and Section 230 gets looked at, and we can now, sue these companies, and we can do something about publishers and the government creating this sort of misinformation campaign, we can now step in and say, hey, we want to do something about this. We want to have this discussion. We want to talk about, we want to secure our rights. This would give the federal government opportunity to go to different countries like France and say, hey, you want to ban our publishing? That's cool. Here's what we're going to do with your publishing, right? It gives us an opportunity to strengthen ourselves and free speech among the West, which I think everybody is on board for, which is why countries had to go about developing their own free speech laws.
Right. I think this is actually bigger than Citizens United. I think this will have an effect on that one as well. And if you guys want to look that one up, it's the thing in the United States with super PACs and how money is given to politicians in certain spaces. I think this will have a pretty heavy effect on that as well. Got anything for me in closing there, Patrick?
No, it's actually a really, really interesting case.
Thomas, you got anything for me before we? Oh, I am so sorry. Go ahead, Patrick.
I was going to say it definitely will change policy across the world. It will have a massive knock-on effect.
Yeah, the follow-on effect will be big. Thomas, anything?
Other than what I just added, no, I think it's, and I'm glad you guys agree, but I think it's going to make, ripples of positive changes across at least the West, at least the, the post-European countries and the West.
The old G7. All right, everybody, like and subscribe, hit the bell, do all the things. We are the A&P, and we are out.